So the panel, I'm very delighted to have three excellent people, all of whom have done a lot of work in this area and have a lot of experience on the general issue of both labor law and the growing sharing and gig economy. Seth Harris is a member of Denton's Public Policy and Regulatory Practice. He's also a distinguished scholar at Cornell. Previous to joining Denton's, he served as Deputy Secretary of Labor for 6 months, Deputy Secretary of Labor, and for 6 months he was acting secretary and a member of the President's Council. Previously, he had been a professor of law at New York Law School. He's a graduate of the New York University School of Law. He's clerked for 2 judges, including Judge William Canby of the Court of Appeals in the 9th Circuit. He received his BS from Cornell, and I understand you may have to leave a little bit early. Thank you. Jonathan Lieber is currently a director of Eurasia Group's United States practice, where he tracks political and policy developments in Washington, D.C. But until just a short time ago, John was the head of policy research for Thumbtank, a San Francisco-based platform for high-skilled professionals in a variety of fields. He previously served as Senate Majority Leader Mitch McConnell's principal advisor on economic policy, including tax and trade. Prior to that, he's worked as chief economist of the Senate Republican Policy Committee and as deputy director at the National Economic Council in the White House. And I'm going to switch right now to introducing Congressman Darrell Issa. We're delighted to have you join us for some preliminary remarks. Congressman Issa represents California's 49th Congressional District in the House of Representatives. He's held the seat since 2001. After graduating from Siena Heights University in Michigan, he was commissioned as an Army officer. After leaving the Army, he went into private business and eventually became CEO of the California-based Directed Electronics, a company he helped found and build, and which eventually became the nation's largest manufacturer of vehicle anti-theft devices. In 1994, Congressman Issa was named Entrepreneur of the Year by Incorporated Magazine, Ernst & Young, and the San Diego Union Tribune. Congressman Issa is currently a member of the House Judiciary Committee, where he chairs the Subcommittee on Courts, Intellectual Property, and the Internet. And he's also a member of the House Foreign Affairs Committee. He chaired and co-founded the House Sharing Caucus, right? Prior to his current positions, he's also served as chairman of the Oversight and Government Reform Committees. Congressman Issa, thank you.
Thanks, Joe. And I'll be brief because, one, you've seen enough congressmen talking here from the looks of the familiar faces. And two, I just want to leave us with a thought, and I try to make it slightly different, but for those who come to many of these Internet of Things, there's some similarities. First of all, this is an educational caucus that we formed because we found that people just didn't get it. When you said Internet of Things, they either said, does that mean my refrigerator's talking to me or is it my Fitbit? But I wanted to leave you with a thought today, which is that the Internet of Things almost has to have Internet disconnected from it. And we need to contrast it with how we got to have the Internet we have today. You know, the federal government made a decision in its own self-interest to connect universities and military installations. In their own self-interest, people basically invented email so they could send and slightly more efficient and easier messages back and forth, and the communication grew from that. But the secret to the internet always was that the bandwidth was essentially self-populating. It was, if you will, an infinite capability, because in everyone's self-interest, they were building or expanding that synchronous 1200, then 2400 baud. You guys don't even know what baud is. I can see from your face that you're going, baud, what's that? Well, that's when you have numbers so small that you can't talk about gigs or MIP or anything else. You're talking about 66 baud is about the speed of a reasonably competent typist. Not a good one, just a reasonably competent. And it wasn't that long ago that was the connection. So let's bring that forward. What was the secret to the internet? Self-interest and self-improvement that gave us greater and greater bandwidth as more and more people innovated, and so on. And so although most of you probably look today and say, well, you know, I'm buying bandwidth. Cox is selling it to you. That's true. But you're only buying it in self-interest. And ultimately, you're paying for the expansion of the backbone. Now we go to the Internet of Things. The problem with the Internet of Things is that it needs two backbones. The easy one, the Internet. The hard one, the bandwidth that exists everywhere for totally mobile devices. So when you leave here, in addition to everything else you're going to learn about, if you will, the future, ask yourself, has government, and if you're with a member's office or are familiar with them, are they thinking of the idea that you need an infinite expandability of the access to grow as the Internet of Things asks for more? And that doesn't just mean the speed of the connection, it means the presence of the connection. I'll give you a real easy example. You're sitting in a room where members of Congress scream bloody murder. We have to have public Wi-Fi in addition to the government Wi-Fi. And so they bought some very expensive Cisco devices that give you both. And then proceeded to block every VPN connection, every port, every activity that would give you secure communication. Now, this is Congress, you expect that. But what if Starbucks did it? Then suddenly you would only be able to communicate if you were willing to do it without the use of your point-to-point VPN and the like. We need to have a policy. You need to think in terms of government must understand that 100% access to enough bandwidth, enough of, if you will, spectrum that is in many cases not currently available, so that anywhere, anytime, a device can remain connected and to the greatest extent possible at, if you will, self-interest, meaning I do it for my reason, you get it for free. Conversely, you do it. So I've taken a lot of time slightly off the subject, but Internet of Things is two things. It's one, government understanding it, and two, government getting out of the way, or at least understanding where they're a hindrance. And for the foreseeable future, the idea that we sell bandwidth and people monetize it has in fact created a crowding of the available remaining space. Obviously, 211 being the one that most people use every day. So I don't have a second thing to leave you with, but I know these gentlemen have many more. Thank you. Joe, thanks for that.
Thank you. So I'll just go ahead and finish the introduction of the panel since I started that, and then I'll present my paper. In the interest of time, I'll just shorten it a little. So Jonathan Lieber, as I said, is a director for Eurasia's group in United States practice. He was previously deputy director at the NEC and economist at the White House Ways and Means. He's from California and attended Tufts University, where he received degrees in economics and philosophy. And I should mention that while at Thumbtack, he wrote a great paper on the role of technology in shaping the market for high-skilled labor. And since I'm giving plugs, I should also mention, I neglected to mention that Seth co-wrote with Alan Kruger a really good paper for the Brookings Institute institution's Hamilton project on gig workers and labor law. Finally, Ross Eisenberg is Vice President for the Economic Policy Institute since 2003. He's a lawyer and former commissioner of the U.S. Occupational Safety and Health Review Commission. Prior to joining the EPA, he worked for many years as a staff attorney and legislative director in the House of Representatives and as a committee counsel in the U.S. Senate. He served as policy director for the Occupational Safety and Health Administration from 1999 until 2001. He earned his JD at the University of Michigan Law School and received a BA from Middlebury College. So I'm hoping that today we can have a discussion not just about the paper I wrote for ITIF, but also about these broader generals of how, first of all, the role of internet platforms is changing work and whether and how we should adapt labor law to accommodate them or to rein them in, possibly, and also how this also affects what seems to be a growing trend of more and more workers finding what are called alternative work arrangements that don't fit into the traditional employee model very well. The sharing economy, or the gig economy, is a small but relatively fast-growing part of the workforce. In his papers, Seth estimated that 600,000 workers currently participate in the gig economy, but 400,000 of those are Uber drivers. So only 200,000 so far are in the rest of the gig economy. In another paper, Professors Katz and Kruger recently tried to update the last BLS survey from 2005, and they concluded that only 0.5% of workers currently use an online intermediary to find work. But this is part of, I think, a larger trend or a larger population. The Freelancers Union came out with a report, I think, last year that found 54 million what they call freelancers, or 34% of the workforce, involved in alternative work. But these include people with more than one job, temporary workers, and also people who work with contracting firms. In a more targeted approach, the Katz-Kruger paper estimates that the percent of workers in alternative work arrangements has risen from 10% in 2005 to now almost 16% as of 2015. My paper divides the internet, the platform users into three sections. The sharing economy, which attempts to increase utilization of capital goods, such as cars, houses, so you could think Zipcar or Airbnb. Then there's the market economy, where individuals sell things like books, crafts, and memorabilia, sites like Etsy or eBay. And finally, the gig economy, where workers sell personal services. This includes Uber and Thumbtack. And I concentrate on these because I think that the argument that platform workers are employees is strongest for people who are selling personal services in the gig economy. And so that's what sort of, those people are closest to the line, and that's where I think it's most helpful to focus the debate. I think that the approach to these platforms should be driven by your general view of whether they help the economy, whether they help users, and whether they help workers. And I think here that the evidence is pretty clear that they benefit workers. A recent poll of 11 platforms showed that 54% are highly satisfied with their job, and another 16% are satisfied. 63% say the primary reason for working is the desire to earn more money. 33% already work for more than one platform, and 43% either have a full-time job or a regular part-time job. The average wage was $28 an hour, and the money brought in from the sharing economy or the gig economy accounted for 22% of household income. These platforms also benefit consumers by offering them lower prices, often due to greater productivity. There's a wonderful paper by Kramer and Kruger of Uber drivers that shows in 5 cities that the Uber drivers were 30 to 50% more efficient than taxi drivers when you measure the percentage of either miles driven or time worked where they have an actual passenger in the car. And so that helps them lower the price. There's also frequently a better quality of service, greater quality assurance due to vetting and rating systems. Uber, for example, does a better job, I think, of servicing underserved areas in this city and other cities. So what are the problems with current labor law? And here I'd like to mention another paper by Richard Carlson from 2001, why the law still can't tell an employee when it sees one and how it ought to stop, why it ought to stop trying, from the Berkeley Journal of Employment and Labor Law. I cited in my paper, but perhaps don't do it justice because it does a wonderful job of discussing the history and the general problem with the common law employee and independent contractor distinction. In most of its major labor laws, Congress doesn't provide a clear definition of who should be subject to the law. Some of the laws have definitions of what an employee or employer are, but these are often very circular. Such as an employee is somebody who's employed by an employer. It's not an exact quote, but it's pretty close. In the absence of a clear definition, courts have resorted to using a centuries-old common law test for employee liability. The test was historically used to determine whether you would be liable if you hired somebody to do something, and then that person caused an accident which hurt a third person. And so the third person could sue the worker, but could he also sue you? And to answer that question, the courts eventually developed a very subjective test that, depending upon the jurisdiction and the issue, has a varying number of factors. Many of these factors are highly subjective. And you all try and get at the question of how much control does the employer have, or does the employer have over the worker? And if you have enough control, you're liable. If you don't have enough control, you're not liable. The problem with the test is that it's highly subjective, including in the weighting of the various factors. And that means that different courts can reach different conclusions. One's status as an employer and contractor can vary from state to state. The status of the job could change over time as the characteristics change. And different workers doing essentially the same job in different places for different employers could be classified differently. This uncertainty invites litigation, and it creates a disincentive for employers who want to help their contractors. So even if you believed that all drivers Uber drivers should be treated as employees. Why would you want to use such an ill-defined and subjective test to achieve that result? Wouldn't it be better to have a clearer black line where people, both companies and workers, knew which side they fell on? And why would we want a test that discourages firms from doing more from people who are independent contractors? Because the companies are afraid if they do more, suddenly somebody will find that they've created an employee relationship. So my paper sets out some general principles for reform. One is that there ought to be clarity. For each of these major labor laws, we ought to try and define a bright line so that people clearly know which side of the line they fall on. Another is that most employers, we need to recognize that most employers, especially platforms, can change their business model in response to laws that they think are bad. So if they're determined to make their workers independent contractors, they can almost certainly do that. It may cost them something, but the benefits of not having an employee relationship may be worth it in their mind. A third principle is that the vast majority of the costs associated with labor laws are passed on to employees. Economists generally agree that virtually all FICA and unemployment taxes are borne by employees. In the Harrison-Kruger paper, I think you cite research estimating that at least 80% of employers' cost of providing benefits is borne by workers. So we need to make sure that whatever benefits we're going to insist on are really worth it, not just to workers in general, but is to the extent we can, we need to make it worth it and valuable to those particular workers who are going to be subject to it in a particular company. And another is that the best employee protection is a strong labor market with lots of vacancies. And so we ought to try and adopt policies such as that. We ought not to discourage firms from doing more for their contractors. And we ought to encourage firms to handle additional services such as setting prices, handling payments, and keeping a rating system wherever this increases the total value to both the worker and the user. So in my paper, I cite 3 alternatives that Congress could adopt. The first is to fix it. We could go, ideally we would go labor law by labor law and define a clear, bright line over where that particular law ought to fall. And for some of those laws, we might want to expand them to almost everybody, including almost all independent contractors. For others, we might want to have a more narrow scope. But I think it's important in each case to have a clear line, to the extent you can, where people know whether the law applies to them or not, and we don't need to have a lot of litigation and uncertainty before we find that out. The second option is to adapt the law, and this follows the recommendation of Harrison-Kruger, who proposed creating a third category of, I think you call it, independent workers. And then these independent workers would be subject to some of the laws, but not others. This still requires Congress to get involved in opening up the labor law and deciding which of the laws will apply to this third category and which will not. It also creates the danger of setting up 2 possibly uncertain lines rather than just one. So instead of the employee independent contractor line, you have the employee independent worker line, and then the worker independent contractor line. And then the final option I raise is to have a temporary suspension of the labor laws, or at least some of them. Largely to see whether companies will step forward and offer their in their workers more services. Some of the services are things that companies could do that would be very valuable to workers, are to take over the withholding of taxes on a voluntary basis, maybe to create a voluntary 401k and even maybe put in an employer contribution, to handle a lot of the record keeping, to provide tax advice and maybe investment advice, and also maybe marketing advice and training to workers so that they could grow their business and increase their revenue. Companies say that they want to do this, but they also say that they're afraid of litigation. They're afraid of building somebody else's case that they've created an employee relationship. And so we could see whether over the space of 5 years companies stepped up and did this. And if they didn't, then we could let the law expire, the exemption expire after 5 years, and we wouldn't have lost very much. I think the risks of doing this are fairly low because I think a lot of these workers are eventually going to be classified as independent contractors anyway. So they're not going to get a lot of the benefits that employees get. And if companies are willing on a voluntary basis to extend some of these benefits, maybe we'll to take it. And the risks are also low because this is a relatively small, though growing section of the workforce. But if it worked, if companies came forward, then it might be a model for this broader workforce of alternative work arrangements. There's just one problem with that, and that is that I couldn't figure out a way to take care of the state law. So every state has its own labor laws, and often these labor laws overlap and essentially do the same thing that the federal law does. And so changing the federal law would only get you part way. If a platform faces major challenges in New York or California or Texas, it may not matter. It may not matter very much what the federal law does. It may still be highly risk adverse and be very leery of doing anything that could change the status of their independent contractors. Preemption under the Commerce Clause, is maybe a partial solution, but it doesn't get you very far. So eventually, it'd be nice to have reforms at the state level too. And so with that, I'm going to turn it over to the panelists, and I'll start with Seth. Thank you.
Thanks very much, Joe. Good morning, everybody. Pleasure to be here. Thanks to ITIF. Thanks to Joe, not merely for inviting me here today, it's a pleasure, but also for helping to move the discussion of this topic forward. There has been I think, fairly robust debate over diagnosing what's going on in the online gig economy, but not enough discussion about prescriptions. And that was what motivated my paper with Alan Kruger, which we released last December. And I think it also motivated Joe's paper, and I'm grateful to him for offering several options among a list of options for how to proceed in this area. I want to pick up on Joe's point about sort of the narrowness of this set of issues, or the narrow applicability of this debate. You have to take out the Airbnbs and the Etsy's, the folks who are selling goods or impersonal services. There are huge regulatory issues, particularly with respect to Airbnb, but they're not really labor issues. So we're really only talking about companies like Uber, Lyft, Thumbtack, TaskRabbit, Homemade, Instacart, that are providing, personal services of some kind. But even within that small sector, and Joe's right that using a really back-of-the-envelope technique, my co-author Alan came up with a rough estimate of 0.4% of the workforce is in this sector. Then when he and his co-author Larry Katz did an actual survey to count it, they came up with 0.5%, and the JP Morgan Chase Institute, looking at bank records, came up with about 1%, about 4% have been in the sector at any given time. So this is a very small segment of the economy, but then you can even further narrow the group of workers that we're talking about. So there's really a spectrum of companies and relationships between companies and their workers. At one end of the spectrum is companies like Upwork, which really is not much more than an extremely sophisticated online classified ads service, where they make available a market, a forum, for reasonably high-skilled workers to offer their services to whoever wants to buy them. Upwork plays no role with respect to determining the services, the pricing, anything that the worker does or anything that the customer does. It's just a pure market. I think you pay a little bit to get on the platform, and that's it. Those folks pretty clearly are not employees of Upwork. They're independent contractors, no different than somebody who's using Craigslist or using classified ads. So that's sort of one end of the spectrum. The other end of the spectrum are people who are undeniably employees. You know, the accountant who shows up, I presume Uber has accountants, I don't know that, but I assume they do. You know, the accountant who shows up to Uber and works 9 to 5 in Uber's facility doing Uber's accounting, that person is an employee. And I can expand that a little bit. There's a wonderful company called Instacart. It's a grocery shopping and delivery service. They have two groups of workers. One group of workers is positioned inside grocery stores, and they're the people who go around the store pulling your groceries off the shelves, putting them into bags, paying for them for you, and then they provide them to delivery workers who deliver them to you. Those people in the stores, Instacart has said, and I think they're pretty clearly right, that those workers are employees. They are working at the direction of their employer in that supermarket, and they're there all day, and they're there for a fixed schedule. Then there are the folks sort of in between, and there are variations on them. Now, the largest of those, and the largest company in this space by a lot, is Uber. They dwarf everybody else. It was 400,000 when we wrote the paper. They're now over 450,000 in the United States, and way beyond that globally. They dwarf everybody else. But there, you have the company involved with the worker, much more. There's a little bit of elements of control, not as much as a traditional employee. You know, there's more involvement in pricing, there's more involvement in, they take a commission off the price. And that's the area we're talking about. So from a numerical perspective, that's the largest part of the segment because of Uber, because Uber is so huge, but it's a fairly narrow slice of activities. If you were to list all the possible options, and there's a Google number of companies, sorry, John, there's a Google number of companies in this space, a huge number, most of whom are going to fail for pretty soon. You better start using them quickly because they'll be gone soon. But many of them don't look like Uber. They don't look like Instacart. And they may not look like Upwork. They're somewhere in that intermediate space. So that's really who we're talking about. So let me just say, is it worth 50 of you extremely talented people being in a room talking about this for an hour for that tiny number of people? We have to honestly ask ourselves that question, and for high quality public policy folks like my colleagues on the panel to be spending time thinking about this. We have to ask ourselves why we're doing it, other than the fact that all of us use Uber or Lyft. The journalists who are looking for trends all use Uber and Lyft, and so they're writing about this stuff, and it's the hot, new, cool, shiny object. My view is that it's worth talking about this topic because it's a gateway into a set of much larger and more difficult issues that we really should be talking about in our society, given all of the statistics that Joe was just talking about. For example, to me the biggest issue is this system we have, this dichotomous system of employee and independent contractor using the old common law rules, is just horrible. I mean, it's just a complete and total disaster. Now, for most workers it's not, and it's pretty clear whether you're an independent contractor or an employee, but there are millions and millions and millions and millions of workers who are in something of a gray area or are forced into a gray area against their will. They're either intentionally or unintentionally misclassified by their employers, and as a consequence of that, they are excluded from the social compact that has been built up in the United States around the American workplace. A whole set of benefits and protections, the minimum wage, overtime, unemployment insurance, workers' compensation, pension protection, now the Affordable Care Act, occupational safety and health protection, civil rights protections in the workplace, all of those things are pegged to whether you're an employee or an independent contractor, And because this system is, to put it in a technical term, really squishy, you can't always tell, and there's too much risk for workers, in my opinion. And there's a lot of evidence that millions and millions and millions of workers are just getting screwed in this system. And it's a problematic system for a whole bunch of reasons, including the reasons that Joe mentioned around uncertainty. We also have a very big question about why it is that people who are workers, but may not be in traditional employment relationships, and are clearly not independent businesses with their own individual bargaining power where they can cut their own deals, are treated as independent contractors and thereby excluded from the social compact. So for example, independent contractors who are just workers, they're just workers, they just happen not to be in a traditional employment relationship, are not allowed to organize and bargain collectively, right? Antitrust law effectively prohibits them from doing that. In my view, that's wrong, and it's unfair. In our paper for independent workers, at least, we propose that independent workers should be allowed to organize and bargain collectively in the form that they want to do it. So I think we can use these issues as a gateway into a larger discussion about the American Social Compact around work and how we dole out these benefits and access to the social compact, and how we do that in a way that is good for workers, good for the economy, and good for innovation as well. So let me quickly comment on Joe's three options. I think it should be unsurprising that by far the best of the three options is that you should adopt my proposal, which is brilliant, and I strongly encourage you to read it. But let me talk about the other two options that Joe presented. One is sort of a law-by-law reform of the definition of employee and independent contractor. And Joe is completely correct in his paper to say that's never, ever going to happen. It just simply is not going to happen. And the task would be so monumentally complex, I don't know how we would do it. But there is an alternative. And one of Joe's top priority principles is clarity in the law. I'm not as big a fan. I think clarity is important, but I don't think it should trump all other values. For example, you could gain clarity by repealing all of the labor and employment statutes in the United States. Then nobody would be an employee and nobody would get access to the social compact. In my view, that would be an extraordinarily bad thing for all of its problems. I kind of like that people get a minimum wage. I don't like this minimum wage, but I think that people should get a minimum wage. They shouldn't be killed at work. You know, just sort of basic values like that trump clarity in my view. But you could achieve clarity by having a simple default rule, which says that everybody is an employee unless their employer, according to a set of very clearly defined standards, proves that they are not, proves that they are an independent contractor. Then in this gray area between employee and independent contractor, you'd always know the answer. It's employee unless the employer can go to court and prove their way out of that status. And let me just say there's a version of that, not quite as clear as I just articulated it in some Western democracies, but that would be perfect clarity. And let me also say it would solve a lot of these problems. It would be very bad, in my view, for the online gig economy, and a lot of the companies in that space would either die or shrink, die faster, or die when they wouldn't otherwise die, or shrink dramatically. There should be another solution. See my brilliant paper. But that would give us clarity, and it wouldn't require a law-by-law solution. Let me go to Joe's, I think his preferred proposal, which is that we give a safe harbor, and then I'll shut up. I've gone over my time. I'm not for that, although I understand the motivation behind it, which is to try to provide clarity. And I also agree with Joe that if companies had more certainty, they provide more benefits. I've talked to a bunch of folks in the online gig economy, intermediaries, the platform companies, and they talk about lists of benefits that they would like to be able to provide to whoever is working with them, but they don't, because they don't know if they're going to end up pushing them over the line into employment status. And let me say, both for compensation and not, I'm asked that question often, and it's very hard to answer because we don't have a clearly defined line. The problem with eliminating or sort of creating a safe harbor, among many other problems with a safe harbor, like who's in and who's out, that would actually be a hard problem. The big problem is that I really like that both sides are facing massive litigation risk right now. You're all reading about Uber and Lyft being subjected to all kinds of litigation. That litigation risk, which is in a high state of uncertainty, the fact that they keep settling these cases and that no federal court, as far as I know, has decided a case about who's an employee or who's an independent contractor in this space. The reason is because there's so much uncertainty, but the risk associated with that is forcing negotiations between the parties. The nicest illustration of that was the Uber litigation in Massachusetts and California, where Uber adjusted its relationship with drivers and created driver associations, which will not engage in collective bargaining, that would be against the law, but they're going to engage in sort of a form of consultation and discussion with these driver associations, aided by traditional unions and my friend Sarah Horowitz at the Freelancers Union. That happened because of the litigation risk. If you got rid of the laws, you wouldn't have the litigation risk. And I want there to be lots and lots and lots and lots of pressure on both sides to come to the grand compromise that we laid out in the paper that we've given you. So thanks for your attention, and Joe, looking forward to the discussion. Let me just say, when I run out at the end, it's not because I'm miffed and you said something horrible, it's because I have to run to a conference call. I apologize in advance.
Thank you. Great to be here. Thank you, Joe. So just a brief introduction to Thumbtack, which you may not have heard of. It is a marketplace for services. We offer over 1,000 different kinds of services: plumbers, dog walkers, balloon artists, whatever kind of service you want to find that week for your kid's birthday party or because your shingles are falling off your house. You can go to Thumbtack and find that service. The service providers on Thumbtack are independent small business owners. There's really no gray area with this particular platform. It's very clear that you do not have an employer relationship with them, and they are not people, we're not setting their rates, we're not telling them where to go, we're not telling them what jobs they can and can't do. We're offering a platform for them to find new customers. Similar to the way Upwork is linking together very high-skilled graphic designers and artists and others with businesses and who need their services. So there's a huge amount of diversity. As Seth pointed out, there's a huge amount of diversity in this space. And what's I find interesting about this discussion is there's really nothing new about the gig economy. People have been working for themselves for generations. People have been going out and finding independent work for as long as work's been around. Thumbtack is called Thumbtack because the idea is we're changing the way that people are finding jobs. It used to be if you were a guitar teacher or a landscaper, you might go down to your local coffee shop and put up a business card with a thumbtack on the bulletin board. And today, you can now go online and try to find new jobs in that way. So there's really not a lot that's new here. What is new is there's these large platforms that are aggregating people together and aggregating these services and these connections together that's getting a lot of attention from Congress, from the press, from everybody else. So that's really why we're here talking about this, is as Seth pointed out very eloquently and also in their paper with a lot of group research, we're talking about this because Uber exists. So that's another point that I'd like to leave you with, is that this all is going to change in the next 5 or 10 years, because the platforms that we care about today and the platforms that we talk about the most are these commoditized platforms where there's service providers that are providing a low-skill service that doesn't require a lot of education and that can be easily replaced by automation. So the fact that these are routine tasks, Uber drivers basically coming to your house, picking you up. You don't really care who the provider is. All you care about is that Uber pledges that he's going to be a good guy and that he's not going to drive you to someplace you don't want to be or murder your cat while he's coming to pick you up your house. This is a very routine service that is easily replaced by robots. And in 10 years, Uber will probably be running a large dispatch service with automated cars. It's no longer going to be an employer, and a lot of these issues are going to be going away. The final thing I'd like to leave you with is that the legal system, as Seth again pointed out, is very far behind where these technological changes are. A lot of the things that we're talking about here, the legal classification issues, are way behind times. They're from court decisions. They're things that courts have decided, not Congress. And when the courts are deciding things, not when Congress is deciding things are frequently vague. When courts are deciding things can be extremely vague and open to interpretation. And so that's one of the problem we're facing here, is that different courts are saying things in different ways, interpreting labor laws in different ways, and it's not really a good way to be legislating in this area. The issue here is a lot bigger than these online gig platforms, though. all the small businesses that use Thumbtack, about 45% of them are employers, and probably a larger percentage of them want to be employers. But the challenge they face is that labor laws that are in place today make it very difficult for them to bring on their first employee. The costs, the regulatory costs, and the tax costs are extremely high. And obviously, we made a decision to push the social safety net on the employers in this country, and these employers have to deal with that. However, it's going to be very difficult for them to make that first decision to hire their first employee because of the uncertainty over how they do it, because of the cost. A lot of them end up relying on independent contractors. So when you're messing around with laws in this space, looking at whether or not somebody should be an independent contractor or an employer, you're affecting a lot more than Uber and Lyft and others. You're affecting millions of small business owners around the country who want to be expanding their business operations. So it's very important that when we think about these issues, when we ask about them, we are mindful of the fact that this isn't just internet platforms. These are people in every community across the country. And to get, that brings me to the safe harbor point, is I actually think the safe harbor is a fine idea for, if you want to experiment that, if cities want to experiment with that, that's fine. I don't have a strong view on that. But you can't really provide a safe harbor for every single person that wants to employ an independent contractor in this country. And that's a far greater order of magnitude of people than just internet platforms. So if you were to do that, it doesn't really solve your problem, because the problem here is much, much bigger than the so-called gig economy that you see online. With that, I'll turn it over to Ross.
Well, thank you all for being here. Let's see, can you hear me? So, I agree with a lot of what's been said here, most particularly that we're talking about a tiny slice. I'm going to make the slice even smaller so that you understand that even though they might have 450,000 employees, Uber doesn't have 450,000 FTEs, full-time equivalent employees. Most of their employment is very part-time. And it actually, their employment represents about 1/7 of 1% of U.S. full-time employment. Just 180,000 full-time employees, full-time equivalents, in a full-time equivalent labor force in the U.S. of over 132 million people. So Uber is, completely dominates what we're talking about, and it is, in fact, a tiny, tiny slice of full-time employment and payroll in the U.S. So my opening assumption is that we shouldn't try to make labor law, and especially what Joe describes as wholesale changes in all of our labor laws based on anything that's, this is really the tail wagging the dog. We don't want to do that based on the Uber experience. It isn't even the future of work. Uber is not. I'm cautioning you, don't think that it's the future of work. David Plouffe describes Uber as, for most people, driving on Uber is not even a part-time job. It's just driving an hour or two a day here or there to make a little extra money. So, again, it shouldn't be the basis for changing laws that govern the ability of working Americans to earn a real living, to be safe on the job, to be free from discrimination, to save for retirement, or any of the important things that people get from work. So I just want to dig into Joe's paper a little bit more. He does call for it. He starts the paper with a call for a wholesale reform of our laws. He says they should apply only to work relationships where they make sense, and Congress, in lieu of that, Congress should create this narrow exemption. So he starts with OSHA and he ends with the National Labor Relations Act. I know a fair amount about OSHA and the act, and so I'll just talk about those two for a little bit. His solution, the problem with all laws is that they're all vague. And his solution would just create a different kind, and actually not all that different kind of vagueness in the law. He's calling for a test of control, and I'll try and show you that is not that different from what we have now. The common law test and the actual statutory tests are of the employment relationship are about control. But the first thing is, why would you want to exclude people from an act like OSHA that has been, in fact, very successful? Why shouldn't you be trying to expand it? And in fact, he doesn't say this in the paper today. You did say you ought to be looking, maybe in some cases, to expand. The costs to an employer of being covered by OSHA I don't think, are enough to prevent any business from starting. And it's important to realize how much good OSHA has done since it was created. The fatality rates in the United States have fallen fourfold since 1970 when the Act was created. It, along with workers' compensation, has very successfully changed the likelihood that any employee will be killed at work. It is a problem, however, that Seth mentioned this, that there is rampant misclassification of employees. So a lot of employees are treated as independent contractors who are not. Millions of them. Every state, when they do an audit, they find that there are huge numbers of people who are being treated wrongly as independent contractors, and the employers are doing that. They're trying to escape the cost of workers' compensation, their obligations under all the labor laws that Joe mentioned, the Social Security taxes. It's not done for the benefit of the worker. It's done as a way to either just save money or undercut competitors who are paying all of those taxes and following the labor laws. So let's think about what it means to be an independent contractor. So you have, let's say, a laborer who is being called an independent businessman, treated as an independent contractor, and he is sent into a 10-foot deep unshored trench by the general contractor. And when the trench collapses and kills him, the question is who is responsible? But if he's an independent contractor, there's no workers' compensation, there's no death benefit for his family. The most important thing is that if he really is an independent contractor, no one else is responsible for the safety of that trench, for making sure that there's wood shoring in it or a metal box that you go in when you're laying your pipe. And it's very unlikely that indigent, perhaps laborers, a not very well-educated person, knows what the safety requirements are. An employer would know them and would be responsible for them. The construction industry in particular is the source of misclassification in the U.S. And I'd say the real reform imperative is to enforce the laws better, to make sure that people are not misclassified. Joe's paper sets out the case of a plumber with 6 different ways of getting work. None of them actually creates any doubt, I think, in the paper about whether the plumber would be an employee or not. There's maybe a suggestion that because in one case it's a part-time employment situation, that makes him less of an employee, but I don't think that that's the case. But what he suggests is that we should have a new test, and it should be who controls the premises. And if you control the premises where the work is being done, that makes you an employer. Or you control the tools that are being used. And so there are a lot of cases in the OSHA field about asbestos contractors. And you can imagine a factory owner, maybe a holding company, controls the premises, but they're actually not on site. But they hire a general contractor to tear out the asbestos. And that general contractor hires independent contractors. And under your test, he would protect himself by not being in control of the tools that are being used. To say the independent contractor will do that. So he doesn't supply monitoring equipment, he doesn't supply respirators or a suit, he doesn't do any of the training that the law requires, and then that independent contractor worker goes in and is exposed to asbestos, and it's not a good test. It's a test that would let that employer off the hook. And we see this. I mean, even under the law, we see employers who want to do this. They hire homeless people to tear out asbestos and buildings that are being renovated, and they end up doing a lot of damage to people. And, you know, I could go on with other examples, but in the interest of time, I won't. I think the discussion of the National Labor Relations Act is equally troublesome. In the first place, Joe's notion of what unions do is very different from mine. The fundamental purpose of unions, it is self-organization of workers to demand better working conditions, higher pay, to advocate for themselves in the workplace so that they get a better deal. And Joe's notion is that somehow they control the supply of workers, and it's true in some couple of industries, construction, garment, there is something called a hiring hall, but usually unions have nothing to do with the supply of workers. That the workers come, and the question is what are the terms of their employment. The union tries to set, most importantly, their wages. And the paper says he can't imagine how this could work at Uber, but I think I can. That Uber is almost exactly who this was invented for, a giant multinational corporation with tons of money that dictates the terms of work to hundreds of thousands of individual atomized workers who have no individual bargaining power. It cuts wages without their consent, except that they continue to work. That's how they show their consent. It has no tipping policies that it imposes on them that can suddenly deactivate or terminate workers, and it lays off workers citywide at a moment's notice. All of these things are the kinds of things that would cause workers to want to join together and bargain collectively. So I think the National Labor Relations Act, which does actually protect non-unionized workers. You know, anyone who engages at work in concert with other workers is protected by the Act Against Retaliation. That's a point in the paper where you suggest that their only alternative is, I guess, is to resort to that they become covered by the antitrust laws if they're not in a union. But you don't actually need a union to be protected by the National Labor Relations Act. You just have to act in concert, in union, with your fellow employees. So, the long and the short of it is, I don't think we need a wholesale reform. I think for this tiny slice of workers for whom there's doubt, I think Seth's test does have the failing that Joe mentions, that it creates 2 gray areas instead of 1. It does require Congress to act, and just as getting them to act to do individual law-by-law reform, I don't think it's likely that they're going to do the kind of reform that you're calling for either. And the damage of letting this work itself out in courts isn't clear to me at all. Uber, despite the uncertainty, has raised $16 billion. The paper this morning talks about how much more money they're raising every week from China, from Saudi Arabia, all around the world. And they do continue to grow. So it may be a while before the Supreme Court actually resolves, 5 years or so before they could get a case all the way up to resolve these issues. In the meantime, the issue could be brought much faster if either the federal government or state governments actually sued, rather than relying on plaintiffs and Fair Labor Standards Act cases. We could have this resolved by government prosecuting under these various labor laws, saying that these are employees, and then having the court resolve the issue ultimately. The other way that this could get resolved is by the antitrust case, which nobody mentioned today. But there is, on the one hand, if these are all independent contractors working for Uber, how is it that they're setting a price that citywide that everybody, tens of thousands of workers or businesses are agreeing to? It could be an antitrust violation. And there is a lawsuit trying his time as the CEO, has been personally sued for conspiring with the Uber driver independent contractors as a price fixer. And if that case proceeds, we may get a resolution to some of these issues. I think I will stop there. Yeah.
Thanks a lot. And then, since we got started a little late, I'll check is, are there any audience questions right now? And also, do we have a microphone? No, okay. Anyone in the audience have a question? No, comment? Go ahead.
Yeah, thanks. Steve Delgado with Net Choice. I have two appreciations for Joe's paper. The first of which is that thankfully he provides an alternative to the world that Seth and Ross have laid out. This notion that you need to be an employee by default unless this startup can go to court and prove you're not would be the biggest innovation killer I could imagine. Even though I read your Brooks paper, I thought there were some other interesting ideas in there. But this notion of employee by default, I believe, is a disaster for innovation. You also use the expression that you'd like to dole out more of our social compact. It's not being doled out, it's paid for by the employers and employees. The government isn't giving anything away. There are no free lunches. And when I hear Ross talk about Uber has a lot of money, Uber raised venture capital to expand its business. They are losing money. They are losing money. You want to wait 5 years for a case, Uber will have used up all of its venture capital at that point. And who knows whether they've got a model that'll generate positive income. So when you raise money, that's a pot of gold, and presumably that you think the government ought to assist workers in going after, but that's venture capital. The company itself is not making money. And then the second benefit I see, Joe, in your paper is you want to encourage experimentation. I'm not sure a carve-out is the way to do it, but this notion of encouraging companies to experiment, to see if they can actually bring more workers on board. Lyft and Uber battling each other all the time. It's fabulous to watch the way they change the benefits they offer to workers to try to bring more of them on board. They try to take them away from each other. That competitive experimentation, what's the environment that would encourage and allow the most competitive experimentation where companies can try to take on certain bits and pieces of the social compact without having themselves fall all the way into the hole of being an employee?
Was there a question in the, was there another question? Did you?
Oh, yes. Will Reinhardt, the American Action Forum. So one of the things I've noticed in the last report that I forget the association, but the National Taxi Association did a large report on their own workers, and something like 85% of all of their current taxi cab drivers are actually classified under independent contractor status. I was just wondering generally if this is just a single industry issue that really has bled over to become a larger part of a larger question, or larger question about rising gig work. I was just wondering what you guys think about classifications just generally of taxi cabs, because again, as I think a lot of people have pointed out, and as I kind of agree, that labor itself is a very different sort of question within taxi cabs as compared to all the other gig economy work. So maybe the question is just located within this industry. Maybe there is just a, some sort of issue with this industry as compared to, gig economy writ large. And I'm just wondering if you comment on those classifications currently within the industry.
Yeah, I think that's a very important point, is that the taxi industry, which is the direct competitor with both Uber and Lyft, the overwhelming majority of drivers are treated as independent contractors. I'm not sure I agree with that classification, but they've been treated that way for many, 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 many years. One of the questions is the extent to which their relationship looks like the relationship that Uber and Lyft have with their drivers. In some cases, I think it's actually very similar. And in our paper, Alan and I suggested that we would not merely apply this independent worker category to the online workers who are working with online intermediaries. We would apply it also offline to taxi drivers and others, because the kind of triangular relationship that you have where the intermediary has very, very limited control, but some control, but the worker decides when, how, where, and whether they're going to work, In that kind of a circumstance, it's not a traditional employment relationship. There's also, I'm not sure it's limited to that industry though. For example, direct sales workers, I think it's worth taking a closer look. We did not dive in industry by industry just because there were limits to the work that we were doing. But the direct sales workers and others also might well fit into the independent worker category. Just one comment about government doling out these benefits. Like it or not, that's how it works. Government decides, either a court or a regulatory agency, and ultimately, or at least at a high level, Congress does, decides who has access to these benefits. So that's what I was referring to. I'm not suggesting that the government pays for it. Government does pay for it in some circumstances in one form or another, either through general tax collection or through targeted tax collection. Social Security, for example, fits into the social compact and is the product of payroll tax collection. It's not a dollar-for-dollar benefit. It does, in fact, work that way, and government governs in this space. The idea that, and this is one of the concerns that I had about the safe harbor approach, is the idea that gig economy intermediaries or platforms are going to provide the social compact, I think is just patently not true. They will do certain things that are in their interest. So I agree with you, Lyft and Uber both are interested in providing mixes of benefits because they have a labor shortage problem. Ironically, they have a little bit of a labor problem. You know, the growth trend that Uber needs to sustain in order to become profitable is really quite ambitious, and they have to attract lots and lots of workers. But they're not going to provide Social Security benefits. They're just not going to do that ever. So let me say, it's more likely that they're going to go to driverless cars first before they're going to do that. So the question for us in public policy is, one, are they getting an unfair competitive advantage by not being required to do that, which others are being required to do? And the other is, what should workers get in return for their work? And I agree that there's a legitimate complaint to be made that in our society, these benefits are generated through the employer, not through the state. And it's a point that John alluded to, and I think is a very, very, very important one. And that is, we should be debating who should provide these benefits and what the benefits should be. I think that's a fair debate. In fact, I'd love to have that debate. And shame on us that we haven't been having that debate. We do it piecemeal in very limited ways about particular benefits. But we should have a broad debate about how we provide it. You know, we're sort of caught up in the path dependence of the decision that was made during World War II. And I agree with you that there are consequences for innovation and small business growth and other issues in our country. But I don't think that the answer to innovation is that workers should subsidize it. I don't think that's the correct answer.
But there are pieces of the social safety net that we've been peeling off from employers. I mean, the Affordable Care Act was attempting doing this. We created HSAs, we have IRAs now, so you can get some of the benefits of full-time work on the private market. You can purchase workers' compensation insurance in the private market if you want. There's a lot of things that you can do in the private market, and it's a worthwhile discussion to think about how we can help and subsidize and incentivize those things from a government perspective. Today, there's a handful of ways we do it. We mandate it. We tax it directly, like unemployment compensation. We provide a tax incentive, like employer-provided health insurance or retirement savings. And in some cases, it's just voluntary, like paid vacation days are just voluntary for employers. Paid vacation days isn't a really good model for gig workers, but there's a lot of different ways that we can get these benefits to people who don't necessarily have to come from the employer. And if you did that, you'd solve a lot of these worker classification issues.
So let me add one thing, which is that if you're interested in outcomes, leaving is, I think Seth is exactly right. You can't leave a lot of these things to a voluntary system. We have a voluntary private retirement system, which has been a pretty complete failure, so that we have the average 56 to 61-year-old family heading into retirement, or the median savings that they have, $17,000. So, leaving this to employers has left almost everybody high and dry. 20% are in pretty good shape and 80% are in terrible shape. So that can't be the solution if you really care about a solution that reaches the great majority of Americans.
Okay, thanks. Sure.
I had one to say Paris, but I know he's got to leave.
Wait.
Great.
Interested in your new independent worker category for fitting into existing legislation and
Right.
what that means as a gateway opportunity to dealing with these kind of larger problems we're talking about. My name's David Barnes from IBM. Particularly when it comes to high-skilled workers, in Europe they've kind of used this categorization in terms of high-skilled workers as what they call autonomous workers. Allowing kind of opt-out or exclusion from particular categories of labour law, like working time. Do you see that kind of independent worker category that your concept brings as being applicable to providing something analogous to that autonomous worker, where you have someone who's high-skilled, well-paid, and relative mobility to determine where they ought to fit within existing workforce legislation?
No.
No? Okay.
And as John points out correctly, the large majority of the workers who are in the gig economy are, largely because Uber again dwarfs everybody else, are low-skilled, low-wage workers. And so they wouldn't fit into the autonomous worker category for that reason. We have, at least in the Fair Labor Standards Act, and also in ERISA, we have a version of what you're talking about, where workers, because of the kind of work that they do, and the view of, at least Congress at the time, that they had sufficient individual bargaining power, that they did not need the protections of the law. We have a version of that here. I query whether or not that kind of individual bargaining power is sufficient to protect you against something like employment discrimination. You know, one of the leading employment discrimination cases in the United States involved a very high wage, very high skill management consultant at Price Waterhouse, what was then Price Waterhouse. You know, the autonomous worker category is very, very, very interesting in the wage and overtime context, but beyond that, I worry about its applicability.
Thank you.
Sorry.
Thanks, Ian.
My name's Danielle, I'm with the Stern Group Inc. I just had a question. Do any of you see probably a relationship between this rampant misclassification of workers and larger social phenomena like millennials flocking to the Bernie Sanders campaign?
I'd take that one. Yeah, I think there is. I mean, there's sort of conflicting evidence, but I think the sector of the labor market can be characterized by alternative working arrangements is growing. And more workers who are either being pushed, or I think most of them are voluntarily taking work that doesn't clearly make them an employee of somebody, let alone an employee of a large company. I think when you add to that there's a lot of unease about where the economy is going, you know, not so much how we're doing now, but you know, how we're going to be doing in 5 years, and then you know, we're still have some suffering from some effects of the Great Recession. I think there's a lot of unease over both how people are doing now and how they think they'll do in the future, and in both parties you've had people come forward and say, you know, we need radical change, and people are sort of, I think voters, without even sort of buying into what that particular candidate is advocating, are buying into just the general notion of we need somebody to come in and shake it up.
So the BLS does a periodic survey that hasn't been funded in a while, where they count contingent workers, and this includes people who are kind of gig workers, maybe driving for Uber. They haven't done this since 2005, they're doing it again in 2017. There was recently attempted to do a private survey that replicated this. And then the biggest portion of contingent workforce that's growing is actually basically outsourced workers. So Congress used to employ directly their cafeteria staff. Now they employ Sodexo, I think is according to my coffee cup, who's the contractor that provides the cafeteria staff workers. So that's the largest growing segment of kind of contingent and alternate work arrangements. It's not actually, as we've kind of talked to death here, it's not actually Uber drivers. I think in terms of like people's desire for flexibility, which is really what a lot of this is about. You're an Uber driver because a lot of people are Uber drivers because it provides some flexibility. I think that's pretty common amongst young people especially. There was a profile in like the Times or the Chronicle a couple years ago of these people living in the Sunset District of San Francisco, and they worked as Instacart drivers by day, and they were TaskRabbits by night, and it was like, oh, we're so free and flexible. And this isn't really a new trend. I mean, 20 years ago, these people probably would have been waiters or bartenders. And I think that like, this kind of notion that there's people disconnected from the traditional workforce and are wanting more flexible arrangements is both a push and pull, where people are outsourcing labor to third parties more, and outsourcing services to third parties more, but also people, especially young people, have always wanted flexibility to kind of work as they please and gain skills or go to school and stuff.
So I agree with what John is saying, that the biggest gain in alternative work is from people who have been contracted out. And why do employers contract out? It's to cut labor costs. And there's no question about that. That's the main impetus for it. And so
It's also specialization, right? I mean, if you're
Flexibility.
with banking, if you're JP Morgan, you want to employ people who do the nuts and bolts of banking. It's not necessarily the case that you want to have, also worry about a large cafeteria staff, which is a fundamentally different challenge for your HR department.
but when you contract out your back office work, you're not doing it to increase your
No,
labor
of course,
costs.
of course.
You're doing it to decrease your labor costs.
There could be, sorry, I guess my point is there could be efficiencies, non-labor efficiencies that are gained throughout.
That's true. My point was that the biggest single reason for contracting out is to decrease labor costs. And if you look, you're asking about millennials. I could show you a bunch of graphs showing how people who are graduating from college now are earning less than people did in 2000. Significantly less, men and women, that they have fewer benefits at work, their starting wage is less, their chances of being underemployed are significant. And then this graph just shows you that what's happened since 2007 in real hourly compensation and wages. At the bottom of the earnings scale, people have not lost that much, but 20, 30 percentile, 40 percentile, all the way to the 80th percentile worker is earning less than in 2007. So, why are people upset? Why do they want change? I think that the fact that they're doing worse and worse in the labor market, despite more and more education, is the reason to dissatisfy.
I think on that note, approach that time limit, and